All right, so we are recording now. We'll get started. Good morning, everyone. For those of you who don't know me, I'm Ashley Lingham. I'm a partner at Montgomery McCracken. I'm presenting today with my colleague Casey, who will introduce herself shortly, on the role of the university in the Title IX rulemaking process. So we started off this presentation, we sort of decided to set it up immediately when President Biden issued an executive order in early March, because we wanted to start getting people together and start getting ideas flowing about the rulemaking process and the best ways to participate in it. We are immediately going to break a promise, and that is going to be the symposium portion of this. So we received some initial feedback from some university clients and colleagues of ours that were concerned about participating publicly without full university approval. So those who wish to remain anonymous, you can change your name on Zoom. You just have to left click on it, and you can edit your name if you wish to remain anonymous. You can use the chat feature, and you can also text me if you have any questions that you want to pose to the group or that you would like discussed. I'm going to give you guys my phone number now. It's 215-932-0400. And I have my cell phone up right in front of me so that if there's any questions or comments, we can talk about them in real time. All right. So let's get started. So let's go over the agenda today. I think that our presentation should be right around 45 minutes with an opportunity for questions throughout. We're going to start by talking about ourselves and what we do here at Montgomery McCracken and the Higher Ed Practice Group. We're going to talk about Title IX and the Trump era rules. We'll go back and forth between calling it Trump era and DeVos era. They are obviously the same. We're going to talk about what the Biden administration has signaled to us so far about a change in the rules and what we anticipate the changes to be. And then we're going to talk about something very important, which is the federal rulemaking process. It's not a familiar process to everyone. And we want to make sure that there is some general understanding of it. And we're going to provide a timeline for everyone for what we anticipate will be the speed with which any changes occur, and then answer questions that you guys might have about the rulemaking process and ways that you can participate. So first, let's talk about one of my absolute favorite topics, and that is Montgomery McCracken. So we have a Title IX and institutional response practice group here that is within the greater umbrella of the higher education department. I have some exciting news to announce about the higher education practice group here, and that is that I have been named as the new co-chair along with my colleague Renee Smith. This is a very exciting news. It is Montgomery McCracken's first woman-run practice group. It's also an enormous practice group. We have many members. We handle all aspects of Title IX, VAWA, Clery Act policy preparation. We offer compliance guidance. We handle reporting, training, investigating, adjudicating, and then most recently advising, which we're going to spend quite a bit of time talking about today. And our higher education group is soon going to be retitled our education group. I believe all of the members that we have here today are in higher education because the anticipated changes to Title IX are not going to be affecting elementary and secondary schools the same way that they'll be affecting post-secondary schools. But we also provide services in the K through 12 space. We also edit and review code of conduct policies, and we work with universities on grievance procedures. And we are SUNY SCI certified Title IX investigators. Our firm is an institutional member, and Casey and I have also personally gone through all of the necessary training using SUNY SCI. My next favorite topic is me. So as I said, I'm the co-chair of the higher education group. I also am in charge of the institutional response and Title IX group, and I'm the chair of our sexual misconduct liability practice. So a little bit about myself, for those of you who don't know me, I started my legal career at the Philadelphia District Attorney's Office, where I was a rape prosecutor for just over 5 years. I then began private practice at an insurance defense firm, a large insurance defense firm in the Philadelphia area. And once I got there, immediately started handling sexual misconduct and sexual abuse claims. Most of those are arising under specific insurance policies for sexual misconduct. And that had turned into a career in Title IX as well. while out speaking about my experience in trauma-informed investigations and practice techniques, I met a whole bunch of folks in the university and college setting, and started handling Title IX, which I've been doing now for about 5.5, 6 years. I also have significant experience in rapid response investigations, which I think has been enormously helpful to our higher education and our Title IX clients. I have a 1-800 number that's available to all clients that gets you access to an attorney immediately, which I think is a big deal for the university members who are on the call right now, who are used to those 2 a.m. Title IX complaint notices, so on a Saturday night. So that's a little bit about myself and what I do here. And another favorite topic of mine is my amazing colleague, Casey. I'm gonna let Casey introduce herself and give you a little bit about her background as well.
Hi everyone, my name is Casey. I'm an associate here in our higher education, institutional response, and sexual misconduct practice groups. I graduated from Villanova Law and did my undergrad at Princeton University, where I was a member of the women's soccer team there. At Montgomery McCracken, I concentrate and focus my practice on Title IX investigations and adjudication, as well as institutional response to claims of sex and/or gender-based harassment and misconduct. I also do some work for our catastrophic sports injury defense group as well, where we work with higher education institutions, focusing on the health and safety of student athletes. So in addition to handling investigations and litigation into both Title IX and sexual misconduct, I have also done a lot of advising and counseling to schools and higher education institutions, really focusing on minimizing risk and managing risk. As a former student athlete, I have really experienced the Title IX and higher education experience in a meaningful way. And I really understand what those decisions and practical implications mean for the institutions. And I'm happy and excited to be able to bring that perspective to my work on behalf of higher education institutions.
I want to make a comment about my colleague Casey here for a moment. With my background as a prosecutor and then moving right into the sexual misconduct litigation and Title IX investigation space, I've sort of always approached my practice from a position of authority and maybe was lacking a little bit of perspective about what it's like to actually live through a Title IX process, to watch a close friend or a teammate go through that process and sort of the way that it affects the university at the ground level. There are benefits to my skill set in being an outsider, but there are also enormous benefits to Casey's perspective as an insider. And working with Casey's just been an absolute pleasure. I feel like she offers perspective as a former student athlete, Division I athlete. I don't know if she mentioned this, but it was Princeton where she played soccer. And she's just a total stud, and it's been really great working with her. So that's enough about us and our team. Let's talk about everyone's least favorite topic, which is Title IX and Trump era rules. Okay. Casey, if you want to get started talking about some of the initial changes that we all saw come down over the summer.
Yes, so thank you for that. And it's been an honor to be able to work with Ashley. I've really enjoyed it. So Title IX and Trump era rules. One of the most significant changes to Title IX under the Betsy DeVos era regulations is the formal addition of the advisor role and the increased participation of the advisor role. So under the previous regulations, an advisor was not owed to a student, and if a student chose to have one, that advisor had to conduct themselves as a potted plant. So they basically just sat there, listened, and did not actively participate. But now with the changes, and probably most importantly, with the change of the advisor role, is the addition of the cross-examination at the live in-person hearing, which we will discuss in more detail in a few minutes. So right now, the regulations say the role of an advisor is to assist and advise the party. So who can sit in that advisor role? In short form, essentially anyone. As you can see, there's no prohibition on the conflict of interest or bias of an advisor, and there's no training requirements for advisors. So if a student wants to, they can choose whomever they would like, whether that be their mom or dad, best friend, professor. It can even be a witness to the investigation right now. So you can see and you can start to think of all the issues and host of issues that this may lead to. And I don't think that was the hope and of the rulemakers. This is the actual regulatory language, which not only requires a live hearing now, but it also requires, like I said, the advisor to cross-examine the other party and all witnesses. A party themselves may never be allowed to conduct the cross-examination. So if a party does not have an advisor present at the live hearing, the school must provide an advisor to that student free of charge. So like I said previously about those, no requirement on the training, no prohibition of conflict of interest. I think the rulemakers intended to make it easy on the schools with that requirement of providing an advisor so that it could be a broad category of who could be the advisor, but I don't think in actuality that's what it looks like, and it makes it easy on the schools. There was, in the previous rulemaking process, there was a lot of comments on this, and it seems like even though maybe the rulemakers had a good intention of easing the requirements on the schools for that advisor role, in actuality, as you may see and have already seen, it's lead to a whole host of issues.
No doubt. So let's talk a little bit about what the rule says about the investigation of a formal complaint in the specific context of the advisor role. So while it seems to be something of a free-for-all as far as advisors go, right? There were, I think when the rule was initially posted last May, which feels like a lot more than, less than a year ago, it feels like a decade ago, but when the rule was initially posted with the preamble and the footnotes, I looked at it, I said, oh, it's about 2,000 pages. And then I hit print and it was about 6,000, right? And this is one of those places in the rules that can get lost. So the recipient, which is the university, may establish restrictions regarding the extent to which an advisor can participate in the proceedings, so long as those restrictions apply equally to both parties. So if we stop and think about those previous issues that Casey identified here, which is that there are no training requirements, that anyone can sit as an advisor, including a potential witness, which is really should make everyone with even a little bit of experience in the Title IX space uncomfortable. The concept, the idea that somebody who could even be a witness to something as serious as a sexual assault, then cross-examine a complainant in that adversarial setting, it should be alarming. There's a little bit of space here within the rule that allows universities and colleges to restrict the participation in the proceedings. I'm going to highlight, though, that it's just in the proceedings, right? So let's talk about what happens in the proceedings, and that is cross-examination. A party does not have the right to ask questions themselves, which is what happened previously under the old Obama era regulations. Any and all cross-examination has to be conducted by an advisor, and cross-examine has to be direct, oral, and in real time. The direct, oral, and in real time, we all know, has been slightly modified because of COVID. It needs to be oral and in real time, but via Zoom has become acceptable. So I want to pause here and talk about some of the pros and cons of having an advisor and having a live hearing. When these rules first came down, universities everywhere were aghast at the concept of requiring a live hearing and losing the single investigator model. But I want to make everyone sort of pause and reflect upon and question whether or not this was really that big of a change because of case law that had come down. So I think everybody on the call is relatively local, and you all may remember that there was a case that came down, John Doe versus the University of the Sciences. It's a case that our firm has had significant involvement in. I actually acted as an advisor in the hearing that occurred after the Third Circuit made its decision. And our university, our firm also had filed an amicus brief on behalf of the University of the Sciences, which Casey personally participated in. because of what was at stake in that decision, which essentially said that due process requires that the parties have an opportunity to cross-examine witnesses in a hearing, and it blew up the single investigator model. So while this rule came down, the Devassier rule came down, and everybody was sort of shell-shocked and stunned at the concept of all cross-examination being live, and that there being this incredibly increased role of the advisor, I sit back and I question whether or not the cross-examination portion of the rule changes is really that big of a change, considering the trends that the courts were following at this point anyway. In my experience, and I think this is something, one of our objectives in our meeting today is to talk about our experience in the less than a year that we've had to live with these rules. My experience as an advisor so far has been that it's not as bad as we thought it was going to be. And there are actually great benefits to having at least trained advisors, and in particular attorneys who have cross-examination skills at the table during these hearings. The fear of a free-for-all of questions, in my experience, hasn't happened, and I've acted as an advisor in about a half a dozen cases, which is actually a lot considering what a short period of time this is that we're in here. So some of the pros are that we get to the point quicker when you're dealing with advisors who know how to conduct cross-examination, who know how to ask pointed questions, and who have a judicial sense of relevance, not requiring the adjudicator to come up with a decision, knowing themselves, this isn't going to come in, that isn't going to come in, this isn't going to be deemed relevant, this will be deemed relevant, actually can support a smoother hearing, and even potentially a more respectful live hearing process when those advisors have some experience here. The con to advisors is what Casey had discussed about earlier, which is that if a party wants one, the university needs to provide one at no cost to the party, right? So let's think about the scenario where a respondent who's accused of a sexual assault has a family with money and sufficient funds, and they hire an attorney to come in. In that moment, what is the obligation on the university if the complainant wants an advisor as well? Is it sufficient to grab someone who's been trained within the university and put them in that spot when the opposite party has retained an attorney and the university is aware of that potential mismatch in skills? In my experience, what's been happening is universities are reflecting on that potential inequity and assigning an attorney. The pro to the universities are that the hearing is going to be conducted a bit more smoothly. The con is the money, is the cost, right? Because this is essentially an unfunded mandate, if you read the rule this way, to say that the university might need to pay for an attorney. In general, those fees can be anywhere from $5,000 to $15,000 per hearing, and that's not including an external adjudicator or an outside investigator, which a university might also have an interest in securing. So suddenly, budgets that did not exist or in the first place are ballooning under these new rules. The reason that I bring all of this up is because we're here to get ready and start thinking about the federal rulemaking process and the types of conversations that you should be having institutionally and externally with outside counsel like Casey and I, and start thinking about what worked, what didn't work for you as a university and as an official, and get ready to prepare it to bring it to the table so the Biden administration can hear about these experiences. So with that, let's talk about a couple of other Trump-era Devassier changes. I think that the advisor live hearing one is the change that caused the biggest stir, that's had one of the largest effects on universities, in particular university budgets, perhaps on the level of panic attacks in the Title IX office about where the funding would come from. But there are some other really important changes that we should talk to you guys about as well. And those are changes that came to the quid pro quo harassment definition and the hostile environment harassment definitions. So hostile environment under Devassier rules was changed to include wording that says that the conduct must be unwelcome, which was always the case, and unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies an individual's equal access to their education. That wording changed slightly, and agita ensued for litigators like myself and like Casey, because we think about what body of law to turn to in the event that litigation occurs, right? Where do we turn to assess in case law that standard when it simply didn't exist before, and also doesn't exist clearly in, say, the Title VII space, workplace harassment? We sort of have no point of reference. I'm not sure that it's been the experience of the schools yet. I can't say that it's been our experience or the experience of our clients that this change in the hostile environment harassment definition has caused the problems that we feared that it might. There were also changes to the definitions of sexual assault, dating violence, domestic violence, and stalking. I again would suggest to you that I don't think that those definitions, reflecting on the past semester and a half that we've had to live with these rules, has caused significant turmoil in the university or college setting. They're close enough to definitions that already existed that there hasn't been I haven't heard of too many issues. Highlighted in red for you though are two specific dossier changes that we anticipate will immediately be changed by the Biden administration. And those changes are that conduct must occur within the context of an educational program or activity for which the recipient exercises control over the respondent, and that the conduct must occur within the United States. Let's talk about the first one. That the conduct must occur within an educational program or activity for which the recipient exercises control over the respondent. What does that mean? What's a real life example of that dossier change? Off-campus, non-university housing. An apartment, I went to Villanova twice. I'm called a supernova for that reason. It's and I live down the street. So now, 15, 20 years later, off an apartment on Lancaster Avenue near Villanova University that hundreds of students live in their junior and senior year, or while they're in law school or in graduate school, but the university exercises no control over. A rape occurs between two students. Those students have to sit next to each other, right, in class. Under this definition, the conduct, the rape, did not occur in a place where the university exercises control over the respondent, because it happened in an apartment building off campus. A cursory understanding of the objectives of Title IX are to provide equal access to education and avoid discrimination on the basis of sex. Isn't that students' access to education affected even though the university did control the place where the conduct happened? I don't think that changing this part of the dossier rules will be controversial under the Biden administration. Everything that we know about what the Obama administration did with Title IX suggests that this is going to be redlined quickly and easily, and likely without much debate. The same is true for the final portion that we'll talk about today, which is that the conduct must occur within the United States. Recently, Casey and I put out an alert about a case that came down from the Rhode Island School of Design. It was handled by local counsel here in Philadelphia, and the Rhode Island School of Design was found to be liable and paid a hefty sum. Off the top of my head, it was over $1 million for failing to protect a student who was sexually assaulted in a university-sponsored program. So we hit that first red mark, but in Ireland during a study abroad. Because it didn't occur within the United States, that particular scenario would not require a Title IX investigation. In fact, the rules would require immediate dismissal of a formal complaint if one were to be filed. But I think everybody on this call can sit back and appreciate that if the conduct occurred in Ireland in a study abroad program, and those students are still in a university-sponsored program, and even capable, the university is capable of being held liable for that conduct out of country, certainly Title IX was intended to protect protect the students in this scenario. The conduct occurring outside of the United States under the DeVos era regulations has not been addressed in the courts. And I suspect that because the clock is ticking on President Biden's executive order, which we'll talk about in a minute, it never will be, because this is going to be redlined. So we talked a whole lot about the advisor role that has dramatically changed. We talked a whole lot about live hearings that have changed. And we sort of skimmed through these other Trump era changes. And the reason that we skimmed through it is because the purpose of today's meeting is to start planning a formal response, public comment to be offered when the Biden administration proposes a rule, right? Stop and think from the university perspective about whether or not it's worth your time, your effort, your energy, your money to invest in commenting on these changes, which might be abhorrent to you institutionally, but are very likely to change without you pushing for it, if that makes sense. So with that said, let's talk a little bit about, with this segue, a little bit about the Biden administration and where they currently have us in getting ready for this. Casey?
So as I'm sure many of you saw, on March 8th, President Biden signed an executive order guaranteeing an educational environment free from discrimination on the basis of sex. March 8th also happened to be International Women's Day, which I'm sure was not misnoted by President Biden. In the first sentence of that order, President Biden made clear the administration's policy that all students should be guaranteed an educational environment free from discrimination on the basis of sex. That discrimination not only includes sexual harassment and violence, but also discrimination based on sexual orientation or gender identity. Consistent with the administration's policy, the order directed Education Secretary Dr. Miguel Cardona to review within 100 days the existing regulations and policies, specifically mentioning and calling out the current Title IX policy. In his review, the order said that Dr. Cardona should consider suspending, revising, or rescinding the current Title IX regulations and any other policies that are inconsistent with the administration's policy. That last bullet point there, where it says the Secretary of Education shall consider additional enforcement actions to ensure protections are in place to prohibit discrimination against students who identify as LGBTQ. As Ashley just mentioned, really focusing on this comment section, what we should, or what institutions should focus and put their push behind. We don't see this as something that the Biden administration will have any issue changing. And we anticipate this will be changed and protections will be explicitly stated in the new regulations. I mean, we have already as a country in Bostic v. Clayton County already decided that it's considered on the basis of sex. So I think this is, again, something that will be quickly and easily redlined. So when considering what to propose changes to in the public comment period, this should be something that we don't, while it's very important, we don't really force and push for because we think it's going to happen right away, immediately. So within 100 days, we are currently right now at day 25. June 16th is that 100-day deadline. So as we get closer to that June 16th deadline, we will be obviously on the lookout to see if any public statements or what is going to come of this review. And this kind of goes into what we will be discussing next in the rulemaking process. So really focusing on that June 16th deadline.
And just to comment on what that June 16th deadline actually means for you in the university setting, it's not entirely clear. So what the executive order states is that the education secretary has to review the current rules. I promise you they've been reviewing it. They were reviewing it the second they stepped in. They were reviewing it when it happened. That process is well on its way. So what might we see on June 16th? We can't answer. It could be the next version of a 2021 Dear Colleague letter, right? Something to hold us over until we get through the federal rulemaking process, which we're about to talk about. But that we have essentially just 2 or 3 months to go until we hear or see something from the Department of Education. It's actually a very short period of time, right? And it's time that you should be using in your institutional setting to reflect upon what it is that you would like to see, because once that June 16th deadline approaches, you might need to act quickly in order to ensure that your voices are heard. And so let's talk about the federal rulemaking process a little bit, which is actually our way of making sure that your voices are heard. So Casey, if you want to walk us through what the federal rulemaking process actually looks like.
Yep. So even though President Biden is taking quick action into his presidency, 2 months into it here, unfortunately, the federal rulemaking process is a long and arduous one that can typically last 1 to 2 years. Congress has enacted procedural statutes such as the Administrative Procedures Act, which sets forth the rulemaking process. This chart that you see here kind of is an overview summary of that rulemaking process. And even though it seems like there's 2 or 6 steps, they don't go as quickly as we would hope or as we would like, but it's kind of divided into 3 sections. You have the draft proposed rule stage, the public comment stage, and then the final rule stage. So in the draft proposed rule stage, the agency drafts that proposed rule. The Office of Information and Regulatory Acts reviews that draft proposed rule, and then it is published to the public for that public comment period. That public comment period typically lasts 60 days. While there's no set timeline for how long that must be, agencies typically give 60 days. It could be a little bit more, could be less, but it's around the 60 days. Those public comments are public. They are published on a website. I think it's regulations.gov. It's a relatively recent new website, but you can go on there. You can see what everyone else is commenting. And there's also other supporting materials such as hearing records, agency regulatory studies. It's placed on what's called a rulemaking docket. So you can go on, you can see those supporting materials and what other comments individuals or schools have made. So once it's done, that public comment period, it then goes to the final draft rule stage. In that stage, the agency has to review and analyze every single comment it got. So under the DeVos regulations, they received nearly 125,000 public comments. That's a lot. Granted, those could be probably bucketed into different issues and topics and things of that nature, but it's still 125,000 comments that they have to go through, read, and address. In that final rule, in the preamble, the agencies typically have to address every single public comment and respond to them. So as you can imagine, responding to 125,000 comments takes a long time. So now you can start to see how this process really does add up. And once that final rule is published, it can't go into effect for at least 30 days. So, we have the 60-day public comment period. Who knows how long it will take them to review all of those comments, and then at least another 30 days for it to go into effect. So you can see how it takes a long time. And the DeVos regulations took a little over 2 years to go into effect. So at that rate, it's possible that we might ultimately not see a new rule in effect until 2023, potentially the beginning of 2024. So while we say, start thinking now so that way we can get these comments together, until we see an effective rule or a rule in effect, it might not be a few years.
And let me comment briefly on the 125,000 public comments. So one of the objectives of getting together and starting sort of this opening a dialogue here and getting a conversation going with university stakeholders is, getting interested persons, and which is all of you, together to start formulating what type of comments you might want to submit, and considering whether or not grouping those comments together would be a more effective way of communicating with the Department of Education. In other words, what comment is the Department of Education most likely to consider and take seriously? One from a random institution, singular institution, or one that has been crafted by council and submitted on behalf of a consortium of universities, right? This is an opportunity that we are preparing for, to have the voices heard of interested persons like yourselves. And we've done this before, where we've acted as essentially, it's analogous to our amicus efforts, right? Getting together, getting our ideas down on paper, making sure that everyone's sort of hopes and dreams are being submitted and considered, and taking it and making sure that your interested person voice is actually going to get through to the decision makers at the top, who are ultimately going to have a say. So we hope that this presentation has at least helped begin the process. We intend to have at least one more presentation like this as we receive additional information from either the Biden administration or the Department of Education. And we hope that this is the beginning of a broader talk amongst stakeholders in the area, interested persons like yourselves, to start reflecting upon what we liked about the DeVos era regulations, what we didn't like about the DeVos era regulations, also what we liked and didn't like about the Obama administration regulations. It shouldn't be presumed that just because Biden was the vice president at the time and had a very active role in those regulations, that he's not willing to learn, and that his administration isn't willing to learn or adapt or adjust. I think all of those things are possible. Also keep in mind that the Biden administration saw some blows in the courts, right? Which I referenced earlier, the John Doe versus the University of the Sciences case, which I bring up a lot because I know it so well and because it was so local, was a blow to the Obama era regulations, right? It required a live hearing and cross-examination. So there are enough changes have happened for us to believe that the Biden administration is actually going to care deeply about the public comment period, and that this is an opportunity to sort of get everyone together to coordinate our thoughts and put a thoughtful piece in front of the Department of Education. We are monitoring very closely the federal docket and all of those resources that Casey referenced earlier. It's a part of what we do, just, you know, when we're sitting down, checking our email and having a cup of coffee in the morning. So this is a space that we're monitoring for you on your behalf as interested persons, and we would be happy to talk with all of you more about that. So with that, we'll open it up for questions. You can use the chat function at the bottom of your screen, or if you'd like to remain anonymous, you can text me. I've gotten one text from a person, which I'll read out loud right now. Do you foresee the advisor role, universities providing an attorney at their own expense, changing under the Biden administration? Excellent question to the person who would ask that. I'm not sure, right? In my experience, the advisor role has not been as bad as I thought it was going to be when I first read the rule. When I first read this last May, I think it was released in mid-May and took effect in August, which was way too fast. That turnaround period was just absolutely too much. But I think reflecting, I'm hoping that this conversation is at least a moment to step back and say, it wasn't as bad as I thought it was going to be. I envisioned, and this was actually in a footnote, this example, and it was also in the public comment period when the DeVos administration had first posted this on the Federal Register in 2019. I envisioned a scenario of the advisor role being a frat boy who was pumping a keg in a basement while a student was raped upstairs, coming in and cross-examining that complainant about how many beers he served her from the keg, right? And it made my skin crawl thinking about it that way. But having handled a half a dozen advisor roles under these regulations, my experience has been that hasn't happened, that the respondents are actually taking it too seriously to do something that gross. They're more likely to get outside counsel anyway, out of fear that they're going to get kicked out of college, and then complainants really have appreciated having a trained advisor by their side. The issue that the Biden administration, I think, is going to take seriously is the cost to universities to paying outside counsel. And at minimum, I would expect the Biden administration to offer more guidance about what's acceptable use of an advisor, whether it's outside counsel or someone internally within the university, what that person should look like, what's their role. Should they be in student life or not in student life? Should it be somebody who has at least a legal background, right? Maybe general counsel or associate general counsel could appoint someone, have them undergo training, and then they sit in that position for everyone to cut costs. These are sort of, I can't answer the question of what they're going to do, but we spent a lot of time today talking about the advisor role because I don't think it's going to go away. And the public commentary period is such an awesome opportunity to reflect on what you liked and what you didn't like, and have your voices be heard on it from the institutional setting. Any other questions? I'm just checking my phone. That's why I'm looking down to see if anybody else has any other questions. Well, you all know where to find us, right? So our contact information we will send out at the close of this presentation. I think we're at 45 minutes right on the nose, like I promised. I hope that this was helpful, and I hope that you continue to join us for our future webinars as we talk about the evolving status of the rulemaking process here under the Biden administration. And we hope that you'll consider speaking with us about the best ways to formulate public comment in a way that will really get through to the Department of Education. Thank you, everyone. Have a good, happy Friday. See you all soon.
Thank you.
Thank you.